Picture yourself stepping off a lengthy international flight into a bustling American airport terminal. Your body aches from exhaustion while your mind struggles through a thick fog of jet lag. Your single desire centers on clearing the inspection process and reaching the comfort of home. You join the queue leading toward Customs and Border Protection officers. Your mind rehearses the anticipated questions repeatedly. Where did you travel from? What was the duration of your absence? What purpose drove your journey? Confidence fills your thoughts because your documents rest securely in your possession. You believe complete preparation shields you from complications. However, most travelers remain unaware that at this precise moment, the distinction between possessing a visa versus holding a green card determines whether they proceed freely through those doors or face extended questioning sessions, potential detention, or formal removal proceedings. A single misstep at the airport terminal possesses the power to alter everything. This examination breaks down these critical differences with precision, composure, and clarity. Immigration law at United States borders demands serious attention because assumptions carry dangerous consequences. Rumors prove equally hazardous. Myths circulating across social media platforms present real threats to travelers. Misunderstanding your own legal status within the American immigration system could ultimately cost you your entire future in the United States. The most fundamental distinction deserves immediate attention. A visa holder and a lawful permanent resident occupy entirely different categories under United States immigration law. Although both classifications apply to non-citizens, the legal framework governing each category at airport entry points operates under completely separate rules and procedures. When entering the United States while holding a temporary visa, whether that document represents a tourist visa, student visa, work visa, or exchange visitor visa, federal law considers you an applicant for admission upon every single arrival at any port of entry. This classification places the burden squarely upon your shoulders to demonstrate admissibility. You must establish that you genuinely qualify for the status your application requests. You must prove your intention to honor every rule governing your visa category. You must convince the inspecting officer that you harbor no intention to violate the terms attached to your authorized stay. A green card holder occupies fundamentally different legal ground as a lawful permanent resident. Under most circumstances, when returning from a temporary journey abroad, permanent residents avoid classification as applicants for admission in the manner visa holders face. Federal law establishes a presumption that permanent residents possess the right to return to their American home. This presumption carries substantial weight in legal proceedings. Nevertheless, this protection has boundaries that travelers must understand. The airport transforms into a high-stakes legal arena at this juncture. Customs and Border Protection officers wield broad authority at the border. Federal statutes and decades of court precedents grant this extensive power. Officers maintain authority to question arriving travelers. They possess power to conduct thorough luggage inspections. They can examine complete travel histories. They retain authority to review all documentation. Under specified conditions established by law and policy, they can search electronic devices travelers carry. Many travelers mistakenly believe that obtaining a visa stamp in their passport guarantees entry into the United States. This assumption proves incorrect under immigration law. A visa authorizes travel to an American port of entry and permits requesting admission from inspecting officers. It provides no guarantee of admission whatsoever. The officer stationed at the airport inspection booth renders the final determination. What constitutes the single wrong move capable of changing everything? The answer shifts according to immigration status classification. For visa holders, the most perilous error involves creating doubt regarding intent. Intent represents everything in these encounters. When entering on a tourist visa, demonstration of non-immigrant intent becomes mandatory. This requires showing plans for temporary visitation followed by departure from American territory. When an officer develops belief that permanent residence forms your actual intention, or that unauthorized employment beckons, or that status violation looms, entry denial can occur immediately. Consider this scenario carefully. You inform the inspecting officer that a 2-week vacation brings you to America. However, your luggage contains copies of your professional resume. Professional certificates and credentials fill your bags. Contact information for potential employers appears among your documents. Perhaps during questioning, you mention hopes of exploring job opportunities while visiting. Even believing you simply engage in networking or demonstrate career initiative, the officer interprets these indicators as immigrant intent fundamentally inconsistent with tourist visa status. In that critical moment, your visa faces cancellation on the spot. The officer holds authority to issue expedited removal under certain established circumstances. Expedited removal carries a 5-year bar, preventing return to the United States. These devastating consequences unfold within mere hours. Attention now turns toward green card holders. Numerous permanent residents assume complete protection covers their status. This assumption also lacks complete accuracy under federal immigration law. A lawful permanent resident possesses stronger rights at the border, but these rights depend upon maintaining genuine residence and avoiding specific legal triggers. When a green card holder remains outside the United States for an extended period without appropriate documentation, officers begin questioning whether permanent residence abandonment occurred. Abandonment ranks among the most serious risks permanent residents face at airport inspections. Generally, when a permanent resident remains outside the United States beyond 6 months, questioning intensity increases significantly. When absence exceeds 12 months without a re-entry permit, the situation grows considerably more serious. The inspecting officer may treat such persons as seeking admission and may refer cases to immigration judges for formal proceedings. Here emerges where one wrong move changes everything for green card holders. When an officer suggests signing Form Y-907, officially designated as the record of abandonment of lawful permanent resident status, and you affix your signature without comprehending full consequences, voluntary surrender of your green card occurs immediately. Once signed, permanent resident status terminates instantly. Removal proceedings may commence, or requirements to apply for a visa like any foreign national may follow. Many exhausted travelers sign documents under pressure simply wanting to reach home quickly. That single signature possesses power to erase years of accumulated lawful status in moments. Another critical difference involves refusal to answer questions or provide access to requested information. A visa holder who declines cooperation during inspection faces entry denial for failure to establish admissibility. Cooperation proves essential because visa holders bear the burden of proof throughout these encounters. A green card holder enjoys greater protections under federal law. Refusing certain questions or declining to unlock a mobile phone does not automatically trigger permanent residence loss. However, such refusal may lead to secondary inspection referral, device seizure, or extended questioning sessions. In extreme cases involving criminal grounds or national security concerns, removal proceedings could still commence. Criminal history discussion becomes necessary because this area presents another zone where single wrong moves generate devastating consequences. Visa holders carrying certain criminal records may face inadmissibility findings at the border. Even minor offenses appearing insignificant from years past can resurface during inspection procedures. When officers determine that crimes involve moral turpitude or controlled substances, admission denial follows. For green card holders, circumstances differ but maintain serious implications. Certain convictions render permanent residence removable from the United States. When officers discover convictions triggering removability, removal proceedings may commence. Generally, entry into the United States proceeds, followed by proceedings before an immigration judge. This process extends over lengthy periods, generates substantial stress, and demands significant financial resources. Misrepresentation constitutes another critical factor requiring examination. Providing false information to inspecting officers at airport terminals represents one of the fastest methods to destroy immigration cases, regardless of visa holder or permanent resident status. Lying about travel purposes, Concealing prior immigration violations or presenting fraudulent documents leads to fraud findings. Fraud carries severe consequences, including lifetime inadmissibility under certain circumstances. Sometimes the wrong move involves no intentional falsehood. Inconsistent answers create serious problems. Telling one officer that your stay lasts 2 weeks, then later stating 3 months, raises immediate red flags. When travel history fails to align with stated explanations, suspicion increases substantially. Officers receive extensive training in detecting discrepancies during questioning. Electronic devices demand discussion because modern mobile phones contain entire lives within their memory. At the border, officers maintain authority to conduct certain device searches. Courts recognize the border search exception, permitting searches without warrants under numerous circumstances. Nevertheless, policies distinguish between basic manual searches and more advanced forensic examinations requiring additional justification. For visa holders, refusing device unlocking may constitute failure to cooperate. Officers may conclude that admissibility establishment has failed. Entry denial may result. For green card holders, refusal does not automatically trigger status loss. However, devices face seizure for further examination. Delays and additional scrutiny often follow. The essential point requires emphasis. The border operates outside ordinary legal environments. It functions as a legal threshold where different rules apply. Rights differ from those enjoyed within American territory. Procedures follow distinct patterns. Stakes reach maximum height. A real-world scenario illustrates these principles effectively. Imagine two individuals landing at the same airport facility. Both spent 8 months abroad before returning. One carries a tourist visa, the other possesses a green card. The visa holder explains intentions to spend 6 months visiting relatives. The officer reviews travel history and discovers repeated lengthy stays within the United States. The officer suspects the individual essentially lives in America while technically maintaining tourist visa status. That suspicion alone suffices for entry denial. Visa cancellation occurs immediately. The green card holder facing identical circumstances encounters questions about extended absence. The officer inquires about ties maintained within the United States. Did you maintain a residence? Did you file taxes as a resident? Do you hold employment? When the officer believes permanent residence abandonment occurred, referral to an immigration judge follows. However, the green card holder generally enters American territory and defends status before a court, rather than facing immediate return abroad. The difference becomes apparent. One traveler turns around at the airport. The other receives opportunity to present arguments before a judge. Employment authorization provides another example. A student visa holder receives permission to work only under specifically defined conditions. When inspection reveals evidence of unauthorized employment, entry denial results. Visa cancellation follows swiftly. A permanent resident, contrasting sharply, holds broad authorization for employment throughout the United States. Employment itself violates no rules. However, certain criminal conduct connected with employment could still trigger complications. This lesson does not aim to generate fear. It promotes preparation. Before undertaking international travel, understand your status completely. When holding a visa, ensure travel purposes align precisely with visa category specifications. Carry documentation supporting ties to your home country when entering on a non-immigrant visa. Maintain consistency throughout all answers provided. Speak only truth. When holding a green card, maintain genuine residence within the United States. Avoid extended absences without proper advance planning. File taxes as a resident each year. Preserve evidence documenting ties to the United States. When planning extended periods outside the country, consider applying for a re-entry permit before departure. Most importantly, refuse to sign documents at the airport unless complete understanding accompanies the signature. When uncertainty exists, Request opportunity to consult with an attorney. Although rights to attorney presence during primary inspection do not exist, declining to sign certain documents and requesting clarification remains permissible. Remember that Customs and Border Protection officers enforce federal law. Their role involves protecting American borders and ensuring compliance with immigration statutes. Your role involves protecting your status through understanding those same statutes. One wrong move at the airport rarely presents dramatic appearances in the moment. It often emerges subtly. A careless statement made without thought, a misunderstood question answered incorrectly, a rushed signature on unfamiliar forms, an assumption that visa possession guarantees entry, an assumption that green cards face no questioning. The airport serves as the front line of immigration enforcement. It represents where legal theory encounters real-life circumstances. For visa holders, risk involves immediate denial. For green card holders, risk involves long-term status loss through abandonment or removability grounds. As you prepare for upcoming international journeys, pose these questions to yourself. Does my travel align with my current status? Have I maintained my residence if permanent resident status applies? Am I prepared to answer questions honestly and consistently? Do I comprehend the difference between applying for admission versus returning home as a resident? Knowledge provides your strongest protection. Calm, truthful communication serves as your shield. Preparation constitutes your defense. Because at the airport, rewinds do not exist, pause buttons remain unavailable. Decisions rendered at inspection booths determine whether life in the United States continues or whether boarding the next outbound flight becomes reality. Green card versus visa. Two documents, two legal standards, two vastly different outcomes. Sometimes, one wrong move suffices to change everything.